What we decided about a year and a half ago is to select this topic for this year. And you will have seen that we have 3 presentations, 4 people talking, 3 presentations. One is a combined one. And we asked them to talk for about 10, 12 minutes, something like that each, and maybe shortly repeating. We will not have a real discussion. We thought that's a bit of difficult to manage, but we think that if we would ask those who would like to ask questions to mention their names and affiliations, and if they would like to label follow-up questions as follow-up questions, then we would at least have partly the feeling that this is a discussion as well. In case of too many questions, I might have to make a selection, but that can be done further on. There will be some theses to be voted upon. Each of the presenters, they have selected 2 theses, and at some moment they will be presented to you, and then you can participate in a poll. And before I give the floor to the first 2 presenters, we are making a live stream of this part of the event, and that will be put on the website of the society later on. So should you miss at some moment something, don't worry. I wouldn't worry too much anyhow. The floor is now given to Wieteke Theeuwen and Marjolein Bustra, and who is taking the lead?
Marjolein will start.
Marjolein Bustra, she is the legal counsel of our foreign ministry. Marjolein, the floor is yours.
Thank you very much. Good afternoon, everyone. I cannot see all of you, but I know you are there, and we will see how this goes with the Zoom environment. Thank you very much for inviting us. Thank you very much for inviting Wieteke and me to do this presentation, but also for writing the report. Can you hear me? Okay, good, sorry. We were very excited to write this report because it allowed us ourselves also to dive deeper into a number of issues that that we deal with on almost a day-to-day basis. As Willem said, Wieteke and I both work for the Dutch government, for the Ministry of Foreign Affairs, and we work on cyber and international law, and we participate in all the international meetings that are taking place on a regular basis where this topic is being discussed. What we try to do in our report is to highlight a number of legal topics that are being discussed and are being debated right now, and provide our perspective on it. So I should emphasize that we are not speaking here in the name of the Dutch government. Everything we say is purely done in a personal capacity. Could I get the next slide, please? Yes, so just a brief overview of our presentation. I must say I timed myself and I realized that I tried to cram way too much in one presentation, so I will probably skip a few things, and I apologize. I will really try to stick to the time, so please go to the next slide already. Just before we go into the legal issues that we discuss in our report, I would just like to highlight that the legal debate that Wieteke and I are participating in takes place against a very politicized context. Now, with international law, that's always the case to some extent. Politics and law are very closely intertwined, but I would say that in the cyber domain, it's maybe even more so than in certain other domains. There are high things at stake, so to speak. On the one hand, you have states who are aiming for an open, free internet that is managed in a multi-stakeholder way, and where the rules are clear for everybody, and also people and states that do not adhere to the rules are being held accountable. On the other hand, you have states who prefer a more fragmented internet where they can control what's happening within their own borders, and unfortunately for some of them also an internet where they can perpetrate harmful cyber operations across borders with near impunity. So there are high stakes and, as I said, many open-ended questions, legal questions that are being discussed, but it's good to keep in mind that all the legal questions that we deal with in this domain have a very strong political aspect to them. Could I go to the next slide? Now, as I said, we touch upon quite a few legal issues that are being debated right now, and I will discuss only one for time reasons, the sovereignty principle. I know I don't have to explain to any of you what the sovereignty principle entails. In the cyber context, there is a controversy, first of all, as to the question, is there a binding rule for states to respect each other's sovereignty in the cyber domain? This may come as a surprise, maybe, but it is a debate, and it is a debate that will take time to resolve. The UK is so far the only government who has taken a very clear position saying that they do not believe that there is a binding rule of respect for sovereignty in cyberspace. The US has some sympathy for that, but so far this position has not yet been endorsed by any other state. But on the other hand, the states who do publicly declare that there is a binding rule of sovereignty are also still very few, amongst which the Netherlands. So this is one of the issues, and we go a bit more into detail in the report. I think legally speaking, maybe a more interesting question is, if you accept that there is a binding rule of sovereignty in cyberspace, how do you apply that rule in the cyber context? Sovereignty is, by its nature, I would almost say, a notion that's very closely connected to a physical notion of territoriality, of borders, of objects and people within borders. And so that means that in practice, it's sometimes very complex to apply sovereignty in cyberspace, where we're talking about information, where borders don't mean that much anymore. And we as government lawyers frequently come across cases where we have to decide, is this a violation of sovereignty or not, which is tricky. Now, the Tallinn Manual, which is, I would say, the most authoritative handbook on cyber and international law that exists at the moment, puts forward a very practical approach. And anyone interested in this matter, I think the best thing is to start there and to look at the approach that they propose. So the Tallinn Manual says that a cross-border cyber operation violates the sovereignty of another state if you could say that it infringes upon the territorial sovereignty of that state, or if it interferes with or usurps inherently governmental functions of that other state. Now, with regard to the first factor, the territorial sovereignty aspect, the Tallinn Manual states that a cross-border operation, if it causes any physical effects, for instance, blowing up a computer, or if it causes full loss of functionality, let's say a computer network that just isn't operable anymore, that there is a violation of sovereignty. The manual says that when it comes to non-physical effects, let's say the deletion of data or altering data, it is unclear whether that would be a violation of sovereignty. And you will see later when we discuss the propositions that we take a slightly different approach, as in that we say non-physical effects can very well also lead to the conclusion that there is a violation of sovereignty. Now, with respect to the second aspect of violation of sovereignty, the inherently governmental functions aspect, the Tallinn Manual says, so if a cross-border cyber operation interferes in any way with inherently governmental functions of another state, there is a violation of sovereignty. Think of the example of police closing down botnets across the border from their own state. That would be a violation of sovereignty because they would be exercising enforcement jurisdiction across their border. So as I said, a very workable approach, but still, even when you fully adhere to the Tallinn Manual approach, there are still practical cases that come up where the Tallinn approach doesn't give a full answer. We go into more detail in the report. I will just highlight one example, and that is the example of, say, police agents carry out a house search somewhere in the framework of, in the context of a criminal investigation. And when they are in the house and doing the search, they find a computer with an open screen and they can access data through that stream, data that's really relevant for their investigation. Now, if that data happens to be stored in the territory of another state, according to the Tallinn Manual, there would be a violation of sovereignty because the police are exercising enforcement jurisdiction on data that is present, so to say, in another state's territory. The problem with that is that most police forces across the world are doing this, are already accessing data in this way. And most of them don't seem to think that there is a problem there with sovereignty. So that's one of the dilemmas that you can come across as a government lawyer. And we propose one solution that you can work with in this type of case is saying that if police access data that is stored in another state in a way that fully respects the national law of that other state, you could argue that that other state, in a way, has pre-consented to that type of access, and that therefore there's not a violation of sovereignty. Of course, this is up for debate. It's only one proposition that could be debated further, but I just wanted to name this example to show you the kind of dilemmas that we work with, and there are many more, some of which we deal with in our report, and which makes it also a fascinating domain to be working on. And well, I have to give the floor now to Wieteke, my colleague, because I'm aware that I'm probably already overstepping my time limit, but I really look forward to debating more on this issue and the other issues that we discuss in our report with you. Thank you very much.
Thank you very much. We now move to your colleague from the Ministry of Foreign Affairs, Wieteke, legal advisor also in the International Law Division.
Thank you. I will now highlight, I'm sorry, there's an echo. Yeah. I will highlight, no, there's still an echo. The sound.
Yep.
I will highlight two parts of our chapters in the pre-piece. One on the principle of intervention, very briefly, and obligations to relating to armed conflict or IHL. I'm aware that we are limited in time, so I try to keep it as short as possible. Maybe a bit technical. We're happy to answer any questions afterwards. According to, oh yeah, we should go to the next slide. One more. Yeah, perfect. According to the International Court of Justice, the non-intervention principle is part and parcel of customary international law. It can be defined as interference in the internal or external affairs of another state with a view to employing coercion against that state. And internal or external affairs are often referred to as the domaine réservé. In our pre-advice, we elaborated on the challenge of the element of coercion in the context of cyber operations. To satisfy the element of coercion, which I will discuss in this presentation, the target state has to be compelled to take a course of action it would otherwise not voluntarily pursue. There needs to be a causal link between the course of action and the changed behavior of the state. In practice, establishing coercion provides a huge challenge. A popular and timely example to illustrate this would be election interference. In the Lex Lata interpretation of coercion, interference with voting equipment is practically the only type of interference that could qualify as coercive, because only then we would be certain that there is a causal link, because the interference with the voting equipment will have led to a different outcome of an election. If we look at propaganda or fake news, they are not likely to reach this threshold, as it is impossible to conclude with certainty that these types of activities would have led to a different outcome in an election. Because how can we be sure that the influencing campaign caused the voter to act in a certain way? You cannot be certain. The ICJ has referred to coercion as forming the very essence of prohibited intervention. But we question if this can still hold in an era where cyberspace is used for harmful interference that almost by definition cannot be established as coercive. In our pre-advice, we offer a suggestion based on literature that would lower the threshold for coercion by aligning the concept with self-determination, by which the causal link would no longer be a determining factor. Cassese once wrote that the essence of self-determination is the right to authentic self-government, where a people is really and freely able to choose its own political and economic regime. Applied to election interference operations, it could be argued that the state's authority and will are manipulated at its source, because the targeting state's influencing operation will affect the environment for the formation of authority and will of the people. In this case, it is not the causally proven effect of the different election outcome that determines whether the threshold of coercion is met, but rather the fact that the right to decide freely is affected or targeted by the interference operation. The right to self-determination as self-governance is affected, and self-governance is protected by the non-intervention principle. So regardless of the outcome of the election process, the violation of this principle could be established because the freedom of choice is taken away. We wrote in our pre-advice that this is not lex lata, but we do think it's rather food for thought. Can I go to the next slide? I'll turn to international humanitarian law, one specific aspect in our report. At the moment, at the UN level, the discussion is very basic. The question is whether IHL applies at all to cyberspace. Some states, mentioned earlier by Marjolein, they acknowledge that the possibility to apply IHL would constitute a recognition of the possibility of armed conflict in cyberspace. They fear that by saying that IHL applies, this may lead to militarization of cyberspace. We argue against this view. IHL regulates the situation of armed conflict, but of course it does not in any way legitimize militarization. The Netherlands and many other states take this view as well. Also, the ICRC are equally of the view that IHL should apply to cyber operations. The UN discussion is stuck at the question whether IHL applies at all. In our pre-advice, having accepted that it does, this leads us to a number of questions. Whether data can be considered as an object, for example, or which operations can constitute an attack in the context of IHL. I will briefly touch upon this last point before rounding up this presentation. In international humanitarian law, attack is defined as acts of violence against the adversary, whether in offense or in defense. The Talent Manual 2.0 defines attack as a cyber operation, whether offensive or defensive, that is reasonably expected to cause any reasonably foreseeable injury or death to persons or damage or destruction to objects. The ICRC has recently taken a more progressive approach by stating that operations causing loss of functionality would also qualify as attack. Marjolein already touched upon this in the context of sovereignty. This would concern, for example, operations that significantly disrupt essential services, such as banking systems or electricity, without necessarily causing physical damage. These kinds of operations pose important risks for civilians. In other chapters of our pre-advice, if you're interested in reading on this a bit more, we noted that cyber operations with non-physical consequences could, depending on the circumstances, be qualified as prohibited use of force, or armed attack. If it makes sense to qualify as an attack on the jus ad bellum, it makes sense that the rules designed to regulate a use of force during armed conflict apply here as well. Thus far, the content-related part of the presentation. Now I would like to turn to the two propositions. Is that okay, Helen? Yeah. So next slide, please. I have to work with the technique here as well. So the first proposition, a cross-border cyber operation with solely non-physical effects upon the territory of another state may constitute a violation of that state's sovereignty, provided that a certain threshold of severity is attained. Such threshold may be established by considering factors such as nature and severity of effects, context of cyber operation, and whether national law is violated. That's the first proposition we would like you to vote on. And the next slide, please. The second one, I already mentioned it briefly. In line with the object and purpose of IHL to protect civilians and civilian infrastructure, limiting the definition of attack as described in Article 49 of Additional Protocol 1 to the Geneva Conventions to physical effects seems overly restrictive. And if you go to the next slide, I guess that's for later on. And the next slide, please. That's it for now, and I'll give the floor back to Wim.
Second presentation, third presenter, Professor Ivo Burema. These days, primarily a justice in our Supreme Court, but also a professor of the rule of law at my alma mater, the Radboud University. Deribo, the floor is yours.
Thank you, Willem. It's great to be here, although I can't see our public, but I appreciate it being invited to give this presentation. As a judge, I'm used to start thinking from the perspective of the reality that has to be dealt with by the law, sometimes also about the effects of applying that law, and not as a true academic would from the perspective of the legal system. However, I'm happy Marjolein and Wieteke took the other road. With their perspective, the voice of international law will be better articulated. And the same goes for the apt observations from the perspective of private international law of Dan Sventerson. I've read their reports with pleasure and admiration. Nevertheless, I like to stress that to have any impact, to be not only correct, but to be also valid, it is important for international law to answer the most urgent questions in the field. And I have tried to identify these in my report from Otpor in 1998, which most of you won't ever have heard of, via the Estonic activities in Estonia by the Russians, via the Al-Kibar bombarding by the Israeli Defense Force, Stuxnet, Cozy and Fancy Beer, the Internet Research Agency of the Russians, and but also activities of the NSA and of British intelligence services. They're all there, be it briefly. But it's more important to realize that the historical reality of the internet shows cyberspace is a worldwide feature of modern society. We may witness cyber espionage and various forms of cross-border influencing, and it's true that we find it hard to know how to deal with these and other types of problems. But it's important to stress that cyberspace is doing very well, notwithstanding the limited role of states. Its autonomous growth is a fundamental aspect of the multi-stakeholder model. Not only states, but also industry, academia, and NGOs have a role to play. And that brought me to a basic question. Can cyberspace be considered a common concern in international law? I think it does. This is the subject of my second proposition, but we won't be voting on that. I just heard from Willem. You can read it in the thing. Basically, it says that part of the common good is territorially bound, cables over land and under the sea. Regarding these cables, I'm inclined to say that the international community should accept positive obligations of states and international organizations to ensure the maintenance of this infrastructure, which is often held by private parties. Another part of this common good is being dealt with by non-governmental organizations, like the e-pay addresses and things like that, the logic behind the whole system of the internet. I fear there's reason to think that this is changing. True, on the one hand, Europeans still opt for a role of non-governmental forces in this respect in order to build a next generation protocol about internet addresses, like the Internet Engineering Task Force. On the other hand, this didn't hinder the Union to develop a 5G cybersecurity toolbox of risk mitigating measures. One of the 9 stated risks is state interference. And now we see a shift. The Chinese were very interested in this European next generation protocol and developed a new IP. Huawei sponsored a conference on the European next generation. The Americans, from their part, were interested in the toolbox and came with its Clean Network program in August 5. So that was almost at the same time as I was sending my report, stating the US wants clean apps, that is no Huawei, clean cloud, that means no Alibaba, no Baidu and Tencent, and clean cables. So where the Europeans really thought in terms of a UN-endorsed multi-stakeholder model in protecting a common good, an unwanted politicization along national interests is taking place in America and Asia. That's dangerous for international connectivity, and that means for trade and for the exchange of ideas. Now, I presume that you're still with me now. But from here, the going gets tough, because even if one starts talking about common concerns, one cannot deny problems of sovereignty. And then opinions might divide. This is exemplified by my third proposition. Maybe it will be the first on the thing we will. You can vote on that. It says peacetime cyber espionage doesn't violate international law, even if it causes a violation of the right to privacy of 22 million people. Wow. Maybe it doesn't feel good, does it? But I will try to persuade you that it's definitely true. Why is that? The proposition has three legs. First, it's an implementation of a basic notion. There is no legal ground to criticize a state that tries to protect its national security by obtaining secrets from another state. Spying in international law is not forbidden. A country might forbid spying and might act against spies, but between countries, it's not a problem. But maybe, and that's the second leg, maybe the enormous possibilities of cyberspace raise the question whether there's reason to leave this notion behind. I would answer in the negative. But I have to agree, covert dissemination via cyberspace of stolen and or false information, one calls it doxing, might give reason to speak of such a violation. It's true, and we already heard something of Wietike and Marjolein that you can think then in terms of the non-intervention principle. I would prefer then to speak in terms of an interference instead of non-intervention, but that's a more specified discussion. Basically, I agree that this type of doxing might be against sovereignty, but not as far as just about spying. Of course, then there is the third leg of the proposition. There's the basic idea that states must respect human rights. How could I deny that in general? But we're not talking about the right to life or the damaging of people's health, but about theft of personal data. I don't think that stealing personal data is worse than stealing military secrets. And moreover, not the one who obtains the data, but the one who doesn't protect them sufficiently is to blame for a from a human rights perspective. The state that lets other states steal their citizens' data doesn't do its work good. Why would the other state be wrong? They're doing it wrong themselves. Finally, if a state really takes into account human rights in a case of mere spying, I'd say it is almost obliged to respond. And that might bring about collateral damage and or blowback effects in terms of escalation between these states that are difficult to contain. So I am glad the US government has refrained from a harsh response to the 2013 OPM hack, when the Chinese probably violated the rights of 22 million people. So maybe an additional system of restrictive measures is urgently needed. I agree with that regarding these types of invasions by other entities, especially if we're talking about deterring and responding to cross-border cyber attacks by individuals and entities, where governmental responsibility is denied. But so far, my third proposition. Now, because of my position on the common good and the multi-stakeholder model, I would like to end with a few words on big tech and NGOs. And that's my fourth proposition is dealing with. The self-regulatory standards of online platforms and leading social networks to fight disinformation are relevant for the development of international law, I'd say. The other pre-advisors are stressing the dangers of powerful parties in cyberspace, like Facebook and whatnot, and the possible decrease of the influence of international law, said Dan. They have a point, I can't deny that. But stressing this position is at odds with the multi-stakeholder view. In my opinion, big industry and private consortia should also be accepted at the table of international law. They seem to be willing to take that role at this moment. They might even be better equipped, for example, for dispute resolution in their communities. Yes, you could say I'm pro-business, but not anti-regulation. The decisions of these private players might be part of living cyber law. The care that befits social intercourse in cyberspace might very well be better defined on these platforms than by states who are prone to the race to the bottom by forcing private parties to prioritize the most restricted laws. But maybe Dan will talk about that more because I just quoted him. Well, insofar, I hope I have persuaded you to continue this mighty relevant discussion on cyberspace and international law with an eye for the notion of cyberspace as a common concern that needs to be protected by international organizations and by the compliance with obligations of nation states. Thank you very much.
And then now we move to Australia. Then Svantesson from Sweden originally, but now working as a law professor at the Bond University in Australia. Most welcome. What time is it at this very moment at your spot?
It is 11:30, so still 6th of November, but we'll see when it ends.
Okay, that's
Thank
a
you so
good
much
open remark. We'll see where it ends, maybe the next day.
Yes.
But most welcome once more, and the floor is yours.
Thank you so much, and I'm very grateful to have the opportunity to speak to you all and to do so in such good company on the panel here. I've really enjoyed the talks by the earlier speakers. Since the question I was asked to address is whether international law is ready for the already ongoing digital age, I had imagined that one of my tasks would be to prove to you all that there is already very much an already ongoing digital age. But look where we're sitting. I don't think I need to convince anyone anymore that we are very much in a digital age. And it's so half my job has been done by COVID already, in a sense, of the things that I needed to argue. But let me say very clearly, I would have much preferred to be with you over there in The Hague and meeting you all. So it's good that the online environment exists and allows this to happen online. But I think we've all had enough of Zoom meetings and so on. So in the sense that we know now that online cannot replace meeting in person. I think that's an important thing to remember. I have often started talks like this with a sort of proposition that imagine that you start thinking that my talk is terribly boring and you drift going on your favorite social media site and post something rude about me. And I hope you don't, but if you do, what country's laws should you then take into account? And normally I'm not talking to such an expert audience like here, so I think it's pretty obvious answers for many of you. But obviously you're in the Netherlands, I'm in Australia, I'm attached to also in one way or another to universities in for example, Sweden and the Czech Republic, so you might consider those countries' laws too. Your favorite social media might be of US origin, so you might need to consider, based on the contracts that you probably read very carefully when signing up for the social media, you might be bound by the laws of the US as well, of California more specifically in many cases. Then things might get a little bit more complicated. If you're writing something that might be defamatory about me, you might need to consider the law of where your contacts, your friends, as we very liberally call them in the Facebook context, are based, or in fact, where they are located when reading your comments. Already there we see that there's absolutely no chance to have predictability as to the laws you are exposed to when doing things online. We could also take account of the fact that maybe your comments will be stored in the cloud somewhere, and potentially that could be a source of jurisdiction for in some countries. leading to the application of local laws in that setting. And then there is, of course, the issue of republication. Perhaps you should really map out the potential location of your friends' friends when they read your original posting. And I would suggest that if you're able to do that, you're probably breaching some data protection laws. So the point here, though, then is we have a very complex landscape from a very basic activity, such as posting something on social media. Let's go to the next slide, please. Thank you. I've talked about this as a form of hyper-regulation. I would argue that the attitude towards regulating the online environment has gone a little bit in a sinus curve pattern, a bit up and down, and now it's certainly on the up. We are seeing a lot of attempts to regulate the online environment. And the problem in a practical sense, from a user perspective, is that we clearly, from what I just described, find it probably impossible to map out the laws that apply to us. And even if we can identify which laws that apply to us, how do we access those laws? How do we understand those laws? And how do we deal with contradictions and so on? This, even though it in many cases might be mainly a theoretical issue, goes to the core of the legal system as such. We have this wonderful principle that's important, that ignorance of the law is not an excuse, as I mentioned here about the Latin phrase. How do we reconcile that fundamental principle with a scenario that I just described, that we know for sure that people cannot know the laws they are exposed to and expected to follow? And as I said, generally maybe it's a theoretical problem, but from a legal philosophy perspective, I think we have some real issues there. I go through things rather quickly. This is mainly to give you an appetite for reading the chapters, and I certainly recommend reading the chapters of a book by my fellow authors. I found them fascinating. Let's go to the next slide, thank you. It used to be that we saw these sort of statements often, and I think they reflected the attitude towards the internet regulation for a long period. With few exceptions, governments can use their coercive powers only within their borders and control offshore internet communications only by controlling local intermediaries, local assets, and local persons. This gives a sort of impression that it's difficult for countries and governments to regulate activities. But I think the proper way to look at what is happening now is to remove rather these words only here. So let's go to the next slide and see what we end up with then. If we remove only, the quote says, with few exceptions, governments can use their coercive powers within their borders and control offshore internet communications by controlling local intermediaries, local assets, and local persons. And I think that's what we're seeing now. Countries are not necessarily relying so much on having their judgment enforced overseas, which often, as we know, can be complicated, but by putting pressure on the intermediaries and so on that might have local assets or local persons, or at least being interested in the local market, they can have quite an impact on what is available online after all. And I discussed this as a concept of market sovereignty. I discussed it a little bit further in the paper, I think, but otherwise also elsewhere. Right. Let's go in a slightly different direction with the next slide. I did some research on Dutch food, and I realized that a traditional main course apparently is meat, potatoes, and vegetables. So it's very similar to what I grew up with in Sweden and also here in Australia, of course. And I think in international law, commentaries, books, journals, and so on, the offline world is very much the main course. It is the meat, potatoes, and vegetables. And online is treated like a sort of slightly exotic side dish, like this, what at least according to Google is a very well-known Dutch side dish, the hosaren salad. I think this is becoming unsustainable. The reality is that, as we see from our event here today, we live pretty much half our life online. So I think international law, both public and private, needs to approach the online on a more equal footing than to compare to the offline world compared to what it does today. So that would be one of my messages here. Now let's go to the next slide, thank you. So I had included my survey questions here, but we can, this is going to be what you will be asked later. And the reason I ask this question, which is there sufficient international coordination and coherence to address cross-border legal challenges on the internet? The reason I ask that question is that that was also asked last year in a survey of the internet community and internet governance community, companies, international organizations, countries, and so forth. And the results that they produced might be different to what you'll produce. We'll see. Let's go to the next slide. So in a sense, the internet governance community came to the conclusion that 79% suggested that there is not sufficient international coordination and coherence to address cross-border legal challenges of the internet. It would be interesting to see what you say in the survey without being affected by this, I hope. But I think whatever the outcome is of the survey as such, it seems to me that the international law community and the internet governance community are a little bit like two ships passing in the night, as the saying goes. And judging by the Lotus case, we know how bad things can go when ships pass each other in the night. So I think we need to be a little bit careful here. I included a link to a download for the report here that deals with the internet governance and international legal issues together that might be of interest. I think illustrative of my point that there's too little interaction is the fact that right now there is something called the Internet Governance Forum going on. And I'm not sure how many here that has had any involvement in the Internet Governance Forum, but I think it's probably the answer would be too few. And I think the same thing of the people who attend the Internet Governance Forum probably have had too little engagement with the international law community on a more serious level. Let's go to the next question, or rather survey question here. I might just leave that one. My question that I will ask you to address afterwards then is, a court in state A orders a party in state B to delete content held by it on servers in state B. The content is lawful under the laws of a state B, but threatened with contempt of court, the party in state B complies with the order. Sovereignty has come up in both previous speeches, and that's why I wanted to include this question for you. Is this a violation of a state B's sovereignty? I think when it comes to sovereignty, the starting point seemed to be, for most people, we have to have sovereignty applying online as well, and we have to work out how it should apply. That is common and it's logical in many ways, but I wonder if there is a risk in that. What if it is the case that we actually can't really apply the concept of sovereignty online? Maybe we need to explore that first before we say that it applies for sure. I think the exclusivity that often is involved in a sovereignty thinking is generally a poor fit with the online environment, but that's hopefully something that we can discuss further. Next slide, please. Connecting to this matter and connecting to a matter raised in the first talk, the situation of law enforcement accessing data on a computer that they seized in their own country, but the data sits overseas. I have argued that that should not be treated as a form of enforcement jurisdiction, because it's very far divorced from many other forms of enforcement jurisdiction, like if we talk about the Eichmann case and so on. Rather, we need a separate category that I, for lack of imagination, have called investigative jurisdiction, that should cover that sort of situation. And we can have a rules around when it's okay to access the data, but I don't think we should fall back on the traditional thinking of enforcement jurisdiction in that setting. Next slide, thank you. On a more fundamental level, I have sought to propose, this was first put forward 5 years ago now, but I've sought to advance a new, in a sense, jurisprudential framework for how we think about jurisdiction, not least in relation to the internet. And some of it is blocked as I read from another screen. My suggestion is that we approach it this way. In the absence of an obligation under international law to exercise jurisdiction, a state may only exercise jurisdiction where there is a substantial connection between the matter and the state seeking to exercise jurisdiction. The state seeking to exercise jurisdiction has a legitimate interest in the matter, and so all these three apply together. The exercise of jurisdiction is reasonable given the balance between the state's legitimate interest and other interests. I could speak a lot about this framework, but I know that there's time limitations here. But my idea here is that this could be, if you look behind the traditional categories of jurisdiction, this is, in my view, the sort of core principles that underpin them. And I think this could be used as a way to think about jurisdiction, and based on these principles, we can then build more advanced rules for jurisdiction in various settings. Another benefit I see in this framework is that, as far as I see, at least, I think it can be seen to apply both to public and private international law. And that's another thing that I think is important. We can see the two fitting, as far as jurisdiction is concerned, there is a common core between public and private international law. This is not an attempt to fully move away from territoriality, the most common anchor point for jurisdiction. Rather, it is trying to say that behind territoriality as a jurisdictional principle only makes sense if it meets these three criteria, in a sense. So if I'm speeding on the roads in Germany, then Germany has a substantial connection, legitimate interest, and there's no other competing jurisdictions that come into play. So I think this framework can work as a foundation on which we build and can apply things like the territoriality principle too. Let's go to the last slide, thank you. One of the key messages that came through that report that I talked to before was this: the internet is neither the problem nor is it the cause of the problem. The internet risks becoming the victim. I think this is a very important way to think about things. We often rush away thinking that the internet is the problem, but I think if we are not careful in how law progresses, not least with the scope of jurisdiction issue that was mentioned by the previous speaker too, I think there's a risk that law might come in, and the way we approach law might come in and actually make the internet less valuable than it ought to be for us. So, and part of a reason why that is happening is that I think the internet governance people have failed to capture the interest of those who are experts in international law, but do not want to devote their whole life to the internet side of things. I think if the general expertise that is found in public and private international law communities could be helping to inform to a greater scale, to help inform the internet governance side, I think we would end up with a better organized internet to the benefit of everyone. And that's the sort of call that I want to finish with. So thank you very much for listening.
The first question relates to the first proposition, not the first, the proposition that was voted upon, but presented by Wieteke and Marjolein. The question is more or less as follows. I combined two. Could you explain a bit under what conditions a as you said it, under what conditions a cyber operation without or with solely non-physical effects can still qualify as what you call it, a violation of state sovereignty. Could you be a bit more specific on that? This is generally felt, I think, to be a very important issue. That question was raised by Dr. Alina from Ontanu. She might tell through the chat where Ontanu is. I don't know. Sorry for that. And there was a second question on the same proposition that was prepared by Wilbert-Jan van Heuvel. He's from the Netherlands. And he agrees to you, but he also sees that there might be an increase of the risk that escalation or that things might escalate into armed conflicts if you allow too many things to happen, so to speak. My paraphrase of the question, Wieteke or Marjolein, it's a bit of difficult dividing word.
I think the first one on sovereignty can go to Marjolein. And is the second question also on sovereignty?
Yeah.
Both on sovereignty?
Yeah.
Then Marjolein can.
Marjolein, you're invited by your colleague to take the floor.
That's okay.
No, that's absolutely fine. Thank you very much. As regard which conditions, under which conditions we feel that you could conclude that a cyber operation with non-physical effects could amount to a violation of sovereignty. I think we have to recognize that if you talk about non-physical effects, you could talk from anything ranging from posting something, a post on Facebook, to interfering in national elections. Both could be the same, by the way, but I think we all agree that there are many different types of non-physical effects. And I think if you open up the possibility of non-physical effects still amounting to a violation of sovereignty, you have to apply a certain threshold. And right now, I think the debate is about that. Where is that threshold? And can you come up with meaningful criteria to determine where the threshold is? And in the report, we don't go into it very deeply, but we say you have to look at the nature and the severity of the non-physical effects. So clearly when many people are affected, or if there is a very significant financial loss, that will more easily qualify as a violation of sovereignty than something that affects maybe one person or doesn't involve any financial loss. Similarly, if human rights are involved, for instance, or the healthcare sector, you could say that those are really crucial types of effects and more easily would qualify as sovereignty. Of course, everything depends on the circumstances of the case, but these are things I think we should look at, as well as the context within which the operation takes place. I think in a context of political turmoil, such as, for instance, in Myanmar, what you had with the Rohingya population, more easily you could conclude that there is violations of sovereignty. Similarly, when there are national elections taking place, more easily probably you can, depending on the operation, of course, that could more easily lead you to conclude that there's a violation of sovereignty. And as a third factor, we think it is reasonable to look at national law. Is the national law violated of the state where the effects take place? Because that is a clear indicator of the type of behavior and activity that a state does or does not accept on its territory. So we think that is a relevant factor to take into account. I hope this answers your question, but very happy to discuss examples. Maybe one practical example where I feel that sovereignty is clearly violated, and you can only speak of non-physical effects, is the Sony hack, where which is generally attributed to North Korea. I don't think the Dutch government has attributed, but generally in literature that's accepted. North Korea stole, so to speak, very valuable data from Sony and published it online, dumped it online with huge financial implications. In such a case, I would say clearly there is a violation of sovereignty. Now, as to the second question, I think, yes, it is with regard to the sovereignty proposition, but I see that it speaks about use of force. And it is true that we also in our report say that non-physical effects, if they're very serious, could definitely amount to use of force. As to the risk of escalation, I don't think that the legal label that you apply to a certain action in itself could lead to escalation. I think rather the action can lead to escalation. But it is true that the issue of attribution is crucial. And as we also say in our report, the more serious the violation of international law is, so if you talk about use of force, it's very serious. There's a very, very high evidentiary standard that states will apply for attribution. They will not very easily conclude or attribute such an action to a state if they're not very, very sure that the action actually originates with another state. I don't know if Vitica wants to add anything to that.
Please do.
Yeah. I apologize, I can't see the exact questions. I didn't see one concerned more than just sovereignty, so I easily pass it on to my name. If you talk about the risk of escalation, I think generally it doesn't really matter which rule of international law you talk about. Like Marjolein said, the risk of escalation is not so much an issue in establishing the type of violation that you are dealing with. If you establish the rule of sovereignty has been breached, that leaves you with certain responses depending on certain conditions that you can take as a state against another state. And if you come to a conclusion as a state that another state has violated the prohibition of use of force, that does not necessarily mean that the measures that that state intends to take in response, if at all, are of an escalatory nature. In practice, what we see is that the responses of states are very measured. It takes a lot of time to come to a certain decision, and this is logical because these kinds of responses, if taken at all, can have huge political but also other consequences. So I don't think there is a risk of escalation in determining what type of violation you are dealing with. It depends on the response.
Could I react a little bit to this thing, or is that
No,
not
no.
the idea?
Ivo Biederman is asking for the floor. Feel free.
Well, I think it's an interesting question because I wonder a little bit whether it isn't, especially example of the Sony hack, which was, for those who don't know, it was a tremendous problem for Sony, and it had all kinds of effects all over the world, in many countries, financial effects, that is a little bit in the good name of some people. Now, for me, it's interesting to realize whether you talk about this in terms of a breach of sovereignty, of, for instance, the United States, as well as Japan, as well as other countries where Sony had its buildings and so on, or whether you should say, no, this has nothing to do with a breach of sovereignty. This is an attack on a company, on a worldwide operating company. And why would you want to speak in this field about attacks in terms of sovereignty? Why couldn't you see it as a criminal attack or something like that? Well, maybe you say, your answer will be, because it's an act of state. Well, there you already have a problem, because very often it's being denied. And Marjolein already said it. It's not quite clear whether it's North Korea or not. And that's why, in my opinion, it's much better not to discuss the question whether sovereignty was breached, but whether you could act as a country defending your company, let's say the United States, by retaliating against those who attacked. And that's something the Council Regulation of the European Union is making possible now, that you don't have to make this move in terms of this was a breach of sovereignty. You can just react to those who acted wrongfully, of course, in established cases. But it was something like Mr. Trump did when the Internet Research Agency from St. Petersburg was doing, was endangering what was happening in the United States during the midterm elections. And then he acted with a cyber attack on the IRA, on the agency in St. Petersburg, not by stating that the Russians were breaking the American sovereignty, but just by making a move in order to let them not act this way. So what I'm saying is, maybe this idea of thinking in terms of sovereignty and widening what a breach of sovereignty is only making things more difficult if you want to react cleverly. And maybe the line of the European Union is better.
Could I just
Would
briefly
you like to react to that, Wieteke or
If that's okay.
Marjolein? Wieteke?
Yeah, I can. Assuming you're talking about the EU sanctions
Yeah.
regime. Yeah. This is an interesting question because indeed that is a thematic sanctions regime that can be imposed upon individuals or entities that not necessarily have to have a link with the state. But sanctions are not, in a way, sanctions are measures of repression. So states can always take sanctions. They don't need to establish that another state has violated a rule of international law.
Yeah.
So the sanctions regime is a good addition, I would say, to which is also something that the EU has, the diplomacy toolbox that they have at their disposal to react to certain cyber operations, whether or not they come from a state or not. And then an interesting point on the reaction of Trump to St. Petersburg, it was, yeah. This is interesting because we of course don't know what the reason was behind this action, but assuming that it wasn't possible to attribute the actions to Russia, in the international law context, how Marjolein and I would probably view it is we, in the absence of proof of it being attributable to Russia, we would look to the state from which territory the operation originated, which is Russia. Russia would have a due diligence obligation to prevent such acts from occurring from its territory. And we, as the Netherlands, if this was the Netherlands, would have then informed Russia, asked the country, the state, to stop this operation from occurring from its territory. And if then there is no response, Russia would have to be unable or unwilling to do anything about it. Then the Netherlands, or in this case the US, but I have no idea if this is what actually happened, would have been able to take, under certain circumstances, countermeasures against the violation of the rule of due diligence. That's how we would have approached such a situation. I'm quite certain that this is not how current President Trump would have approached it, but this would have been my analysis from a Dutch perspective. But the EU sanctions regime is it's a really good one to mention. It's very interesting as a tool that we have against persons or entities. Yeah.
Thank you very much. In the meantime, I have quite a long row of questions, and before addressing the next one, I should make a correction. The name Alina Ontanu was the first name and the last name. It was not a place on earth, but it was a last name. Thank you for clarification. I have a question for Dan. I'm not sure, Dan, whether you can see it as well, but Miguel Andres Lopez Martin from, I don't know, raises a question to you. He is asking you whether you think that the final victim in the context of today's discussion would be the humanity as a whole instead of the internet in itself. That might
Yes.
also relate to the dual use of internet as a tool, but you might have seen the question. Could you elaborate upon that?
Yes, I think in some ways it's useful to start thinking about the internet a little bit like we do with the environment. We are seeing a climate change also online. And when we speak about the natural environment, we often talk about tipping points beyond which it's going to be very difficult to go back to where we were before, difficult or impossible to go back to where we were before. I think it's useful to start thinking about what could be those tipping points in relation to the online environment too. So I think, while I agree, the internet without humans will hopefully never fill a function in a sense. We should be the ones who benefit from it. I agree. Humanity should be the ones benefiting from the internet. But when it comes to ensuring that we can maintain the internet that we want, I think it's useful to think of it then in a similar way that we think about the natural environment.
To the thesis defended by Ivo Burma about the use of internet as the common good, as part of the common good. We have different views on that, Dan and Ivo. Or do you in the end agree that, let's say, that it is key to treat the internet infrastructure and everything linked to that as a common good, or should it be left to the private parties? And if the latter, then another thesis comes up defended by Ivo that big tech should be part of international lawmaking. Dan, would you like to react to these two aspects?
Yes, I think that this idea of the internet as a common good or in an international space even has been discussed for some time, and it's an interesting one. I think the idea of it as a common good rather than as an international space is a better perspective. It's definitely something that we have a shared responsibility for looking after. At the same time, what we're seeing right now around the world is going in the exactly opposite direction with a balkanization or fragmentation of the internet, and that's of course also mentioned in previous speakers' paper, where we're seeing countries and companies drawing up their own cables, potentially for some of them with for the purpose of creating at least the potential for its own internet. China has done a lot when it comes to its Belt and Road initiative to have a digital and internet arm of that. And we see a potential then when we see in things like the Huawei situation and so on, we see the potential for a split where countries around the world are going to have to decide if they go with perhaps a Chinese internet or a Western internet. And that a lot of people are concerned with that, concerned about that, and that might be a direction that we might be heading. And then we have failed to ensure the common good in a pure sense, at least.
Something?
Yes, small addition, because I agree completely with Dan and what he's saying as a diagnosis. But I would like to add the one thing that I would say that is in the interest of Europe to try to bring, for instance, the United Nations in a position that it keeps on thinking in terms of a common good and in terms especially of a multi-stakeholder model. Because it's true what Dan says, that it looks as if things are changing into the other direction, into the balkanization of internet, or whichever way you want to describe it. And I think it's in our interest to try to find this interconnectivity between this Chinese and the Americans and go on in the way we did it. That's why I'm so strongly stressing this. This doesn't mean that we keep things like a kind of a anarchy on the internet. I can imagine that we do some regulation a little bit more than we had, but I think Dan's diagnosis just underlines the idea that there is a role to be played in the United Nations, and maybe that will also, well, keep it going then, because at this moment it's difficult for the United Nations to find one position. You can see that because of all these differences, well, maybe Europe can have special force in the discussion over there. But maybe Wieteke knows more about those kinds of things than I do.
Let's move to another issue, which is tabled by, let me check, Rebecca Mignot-Madavi. Sorry if I don't pronounce the name correctly. She's working at the Asser Institute. She has an interesting comment, but also a question: how to deal with data in international law, ownership, responsibility, ways of dealing with data, maybe a state perspective on that. Wieteke?
I'm first going to ask Marjolein if she wants to take the floor, and if not, I will answer because I can't see her, so I can't signal to her.
Marjolein, you are invited to take the floor. Did you hear my question?
Yes, I actually see the question in front of me, and it's about data as an object in the context of IHL. So in that sense,
okay.
I think
I'll
that
take the
yeah.
In this context, what we have discussed in our payout fees is the current debate concerns the question whether data should be considered an object, because if it's considered an object, it should be taken into consideration in targeting operations. And sorry, is there? I see some people. Do I have to speak louder? Okay, excuse me. In the context of IHL, if data would be considered an object, we would have to reconsider all our operations with regard to targeting. So all the principles of IHL would then apply to data as an object. And in our payout fees, we offer a number of positions on this topic. We have authors who make a distinction between the types of data that could or could not be considered as an object, where, for example, content data and operational data are distinguished. We also note that currently it is not clear yet whether data will be considered an object in IHL, but at the same time, some data is already protected because it falls under certain categories in IHL, such as the protection of medical staff and equipment, medical facilities. So if it concerns, I don't know, patient data in a medical facility in IHL, these are already protected. So there are certain already protected types of data that are protected because they fall under some category. And the general discussion on data as an object, as many things in this discussion, has not been settled yet, but we offer a few, based on work of our colleagues, a few options that might be worth considering and that may evolve into customary international law in the future.
Could I go back for a second to the question on big tech as inviting big tech at the table of international lawmaking? Ivo, would you like to say something more on that? Maybe something controversial, and then I will invite the representatives of the Dutch Ministry of Foreign Affairs. I give them some homework, so to speak.
Oh yes, that would be nice. They don't have to do enough. Well, of course, it's difficult. It's important to make a distinction. When I came up with this issue of asking private parties on the international floor, my first idea was with the academics and those of these consortia of making the internet, like I just mentioned this, where to find it, the IETTF, the Internet Engineering Task Force, and so there were many more, W3P and so on, who are dealing with all these technical stuff. So that's not really big tech. These are, you might say, NGOs or something like that, working with the infrastructure of technology. I would think, and I know, for instance, that the ITU, which is a governmental organization, is trying to work together in part with organizations like these. It's not completely closed boundaries, but you could say, well, it's important to go on like that and not making the ITU more of a real state-like or governmental organization, where, for instance, those who prefer a real national sovereignty-like input, like the Chinese one, and maybe the Americans also want, to bring that a little bit back. So to stimulate them to go on with discussing with academia and with these types of NGOs. Your question related to real big industry, big tech, like Facebook and like Microsoft. And as you know, for instance, regarding the issue of anti-terrorism and things like that, and now with also with the how do you call it, the wrong news, false news, fake news, that's the word. With fake news, there are initiatives of the biggest groups like Twitter and I think also YouTube, but now I'm speaking out of my head. I mean, there is a consortium of 4 or 5 of these. I think it's interesting to talk with these people and to have them on the floor, because then you see how difficult it might be in practice. You might say we are against fake news. Like in the beginning, there was the saying, we don't want terrorists, Al-Shabaab and Al-Qaeda on internet. And so then I think it was YouTube closed the internet for certain pictures, because of course it has to be done automatically, digitally. And so they cut off everything. But the price was that human rights organizations also couldn't bring their news anymore on YouTube, because it also fell out. And these types of issues, where you have to find a balance between, let's say, censoring or other activities you don't want to have on Twitter or YouTube or whichever other platform, can only be dealt with in a realistic way by these organizations themselves. And that's why I would like to, well, bring up the idea that if you're talking in international organizations like the UN, GGE, and etc., that you also should invite spokespersons from these important and also well-thinking organizations from the private enterprises. Doesn't mean that you couldn't attack them at other moments, like when they don't pay their taxes or something like that. But when you want to change the internet, you have to deal with them as well.
Any reaction, Witteke or Marjolein? Witteke first?
Yeah, sure. Yeah, interesting. I read about what was it, the Global Internet Forum to Counter Terrorism in your piece. Very, very interesting. And it's true that on the one hand, as governments or as the Netherlands or in more personally, we are often approached by big tech companies who also have international law departments. Microsoft, for example, does, I know, and they have all kinds of ideas on how we should regulate cyberspace. They do, of course, recognize that international law is made by states, and states are subject to it, with some exceptions, of course, in the human rights context. But when you look at NGOs and other international organizations, we speak in a personal capacity, but the Netherlands finds it very important, as well as other states have expressed the same, that these organizations are invited, at least as an observer, to discussions at the UN level. In previous years, we have organized informal consultation sessions, I think they are called, prior to the formal GGE or open-ended working group meetings at the UN level that are meant for states to discuss, we invited a lot of organizations to come to the table and present their arguments. Unfortunately, not all states at the UN level share this view, and they have at times blocked participation even as an observer. So that is very regrettable. The input is very valuable, yeah, we do hope that this changes a little bit in the future, but thus far we are sometimes limited to informal conversation with these organizations. But yeah, it is what it is. Yeah.
The summary of one of the questions says it might be a vulnerability, but nevertheless you might have to deal with it, even if it's problematic in one way or another. You still might have to deal with these types of issues, even if they might pollute lawmaking.
Yeah, that's true. But you mean the participation of the organizations?
Yeah.
Yeah.
It's an open question, my framing.
Okay. Well, I personally, and I know that this is also the view of some countries, you don't always have to agree to have a discussion, and it's always important to talk with other stakeholders and states. The multi-stakeholder domain is, at least for European states, it's not even a question. It's a fact that it is a multi-stakeholder domain. And European states, whenever they get the chance, they will of course try to bring this to the international level. But it doesn't always have the desired results.
Acceptable. I have a very small question for François Delegue. My feeling is that your question has been responded to, but if not, I can come back to it. And I would now like to move to a question raised by Cedric Reyngaard, Utrecht University. He has a question on sources of law. That's one that's a bit linked to the previous one. In international law, we of course have a number of formal sources of law. And how can we integrate self-regulatory standards into that? Could we move that into the traditional sources of international law? Maybe amongst others, customary international law or the general principles. And even if it's not your field, you might have a view on that.
You know, if you say A, you should go on B, but now I have a problem because I don't know so much of B as many others of the audience. So I'm a little bit in doubt whether my reaction would be clever or not. What I was thinking was that, and that's, I can imagine that Cedric thinks I'm a little bit vague when I'm saying what I'm going to say. But once just before 1919, the Netherlands judges were always thinking in terms of what the law said. And at a certain moment, they introduced the notion that it's necessary for judges to look at what befits social intercourse. That's the Lindebaum-Cohen verdict of 1990, and there was a moment that the judges accepted that you can have a legal importance, can give legal importance to what's customary in a certain field. Now, I'm not accustomed enough with international law, and I can imagine that it's a little bit too much to say that you could call it a custom, because what's happening in internet is so young that everything which you call a custom might be ludicrous after some years. So I'm a little bit scared to make that comparison. But to make the comparison that you might enter what's customary in some way, well, I'm looking now terrified to those who do have expertise in this, but it wouldn't be the first time that in some fields, even in the Netherlands, which doesn't have the Anglo-Saxon system of working with the law, even there you accept at a certain moment the influence of non-strict regulations and laws, be it only in terms of comply or explain and things like that. And that's the way I would be searching for a solution for his question. But I need him to give a better answer.
No, I think it's, if I may, I think it's a very good answer. In international law, we have quite a number of people who are extremely traditional, and then your view might not fit at all. And many people are coping with challenges that occur all over the world, all over the globe. And then at some moment you have to make it fit in one way or another. And if you also know that quite a number of states are not democracies at all, they are types of regimes that have their views on a variety of things sometimes, then other actors might have to step in. And then there is, let's say, some space to do that. Cedric Reingaard, I'm not sure whether he will be satisfied. It depends a bit. He is a progressive thinker in many ways, and he will try to make it fit as long as it's relevant and sustainable, built on solid ground. So I would say your answer is not strange at all, and it orders us to seek for new ways forward. I have several other questions, but one in between. We are living in an era, you might say, where neoliberalism is very well discussed in many, many ways. Limits to market orientation, limits to some extent capitalism, while in many ways money is made these days by using data in a way which is not consumer friendly. And let me come back to that question, because that's one that pops up in each of the three reports. What should we advise? Should somebody ask me tomorrow, what should we do with these types of actors, big tech firms, those who sit on that huge hill of data and do whatever they like without having a view on the public good, turn point, the common good, turn point, acting in the interest of humankind at large? I would add, that's my personal take on that, how to act in favor of developing nations. Many of them, let's say, are followers, but not in the lead, and they do not profit from the way data are used. Maybe in the order of far away first, Dan. Would you like to react to this?
Yes, thank you very much. I have elsewhere proposed that all these big tech companies that are data-driven, making the profit from data, should be required, and I think they won't like this necessarily, but I think they should be required to have a pay-for version of their service. So let's say that you are using a search engine. You could have a free version that we use now, but you should also be able to subscribe like we do for so many other things, Spotify, Netflix, whatever, subscribe, and then the search engine should only collect the data it needs for processing your request, not using it for advertisement and so. We would have to set rules for what is a reasonable amount to be charged for it so it can be functioning and so on. But I think from a consumer perspective, to deal with this data-driven economy and the negatives that comes with it, I think that could be one approach. Another question that I think you were raising was how we deal with the fact that some states are very much the rules setters, while others are the ones that have to comply with the rules set by other states and by the big companies and so on. We need to be better, and this links into the previous discussion, we need to be better at ensuring that all interests are represented when big decisions are made. As it is now, the whole arena that everyone works on is very much set, the rules for the whole arena is set by the big companies discussing with the big countries. Even mid-sized countries feel excluded from the rule making, and we need to get better at that. That would be my answer to this.
And I started far away, and now we are in The Hague, and in The Hague.
And in London.
And in London,
I
right.
think
Marjolein
wants to say something.
Would you like to add something on this?
Yes, please, because this is a topic that in a way is close to my heart. I'm originally a human rights lawyer, and I'm reading and thinking a lot about human rights and technology, and especially this issue of big technology. And we actually deal with it in our report as well. I would say, yes, we definitely have to include big tech actors and engage with them and talk with them. But in that sense, I'm a bit traditional to say that big tech companies are not democratically elected, and they do not pursue the, even if they may wish to present it as such, they do not pursue a general interest. In first instance, their interest is in keeping the company viable and having a solid business model. So that, I think, is a crucial distinction which will make, or should make, I think, that they can never sit at the table at the same level as states. And not to say that they are a big part of the solution, hopefully. But there, I would like to say that personally, I feel it's very dangerous to leave important decisions, important things where we as democracies should have a very strong debate on, to leave those decisions to big tech. And then I'm talking about exactly the responsibility. What type of content do you allow on your platform? How do your algorithms work? What type of algorithms are acceptable or not? And mainly I approach this from a human rights perspective. I know there are different ones, but as my background is in human rights, I look at it from a human rights perspective. And I think these are topics that are too important to leave to big tech. I think they should be at the table, but they should not be given the responsibility to make these decisions. And at this time, most states leave that responsibility to big tech because they don't feel equipped to make those decisions themselves, or because they are afraid to violate human rights, such as the freedom of expression, by setting rules. So it is very complex and very difficult, but I do think that states should take a bigger role here in this respect, and that they leave way too much freedom to big tech companies. I realize that for smaller countries, such as Dan says, it is harder, but I do think there are still many opportunities to do so, especially for smaller countries, part of the European Union. I personally think the European Union could play a very important part. The EU has set a standard with the GDPR. The GDPR is not perfect, but it is a very good example of how, when the EU sets a standard, others sometimes follow. And the GDPR is kind of considered as the golden standard of privacy protection at this moment. And a final remark, I think there's now in competition law mainly a very big discussion about, should we break up big tech, especially because they have so much influence and sit on data. I think it's a very relevant and interesting discussion. And I think it should also, this discussion should also be held in the context of human rights. And we put forward in the report the concept of plurality of the media. In the context of the freedom of expression, there is a doctrine that countries have a positive obligation to ensure the plurality of traditional media. And when this doctrine was developed, we were talking about newspapers and broadcasting companies. I think personally that these big tech companies, social media, that we should have also a doctrine of plurality of these social media, and that states have a role there, and that they should maybe consider more interventionist strategies to make sure that these companies take better care of data and maybe collect a bit less data. Final remark as to the proposition of forcing big tech to offer paid services. I think it's a great idea. I only see one difficulty, is that there is a danger that then you will have in society those who can afford to protect their privacy and those who don't have the means. So in that sense, I think that is tricky, and that's a risk that should be addressed. But very interesting proposition. I think we need these ideas, and we need to talk more about them, how to deal with this problem, because I do think it is a very big problem and a big risk, even though most people use Google without any concern. Thank you.
May I quickly respond to that one? Yes. I thought about that, and that's one that you hear often as a response. I agree. What I'm proposing is not an alternative to the framework we have now, though. So the golden standard of a GDPR, as you talk about, would still be applicable. So those who choose to not do the pay version still enjoy the basic protection that they get under the law as it stands now. It's just an additional option for people. And on the topic of it becomes only for those who can afford it, the price obviously it could be set at if you think about your Netflix subscription or Spotify or something, it's not something that normally break the bank. So it should be on that sort of level where it is reasonably affordable. So it would have to be subject to some sort of control in that setting too. I know it sounds a lot like a nanny state approach, but I think it could be a workable option.
And then we haven't even been talking about international European tax law. Wieteke, would you like to add something about this topic?
Yeah, well, I know here's, yeah. I do, because Marjolein was really, how do you say that, fierce in her remarks. And I agree, of course, that countries should think about these themes, and I think they do. It was also a European invention to think in terms of the right to be forgotten, which was a very good idea. So I can imagine that in terms of regulating big tech, there's nothing wrong with that. If you have good ideas, sure. Even if you have golden standards, also fine with me. But I also have the idea that there is something, the idea that big tech is so rich and so powerful, it seems, that makes people scary. And then I want to also highlight a big positive thing of this. It's not only negative. If I'm thinking in terms of, let's say, the steps forward for medicine, the way the Google especially is indeed trying to get all this information about people's health, but the way it works back in knowing about these 50 people with a certain illness all over the world, and these doctors can find one another, and it's only because you have these huge amounts of data in the hands of one company, Google, then you might say, yeah, is that so bad? And at the moment that you are asked to deliver all your medical information, you might say, oh gosh, this sounds like against human rights and things like that. This is against privacy. But without it, you can deliver this knowledge we, thanks to Google, have. And of course, Alphabet, the mother company of Google, is extremely rich. But that's for me not a reason to say, look here, they shouldn't have all these data, because without the data, we wouldn't go forward as we do. So for me, what Marjolein was saying was a little bit too strict. I mean, I can imagine that you want to make more regulations and so on, but please be careful, because I think it also is a big step forward for humanity that we have all these data in let's say, in a way that we can use them in a positive way. Here, in this example of health, but also in other examples. And also, for instance, for people in the third world. I mean, there are, of course, people in poor countries who can have trade now, even to Europe and the United States, with their stuff, which they could never have sold when they were, how do you say it, dependent on all kinds of local dictators and whatever kind of people. And they can do their business now in this way. So I'm not as negative as I have the impression those who are fearful of what the big tech is doing. Of course, I know they will make mistakes. Sometimes I'm scared of Mr. Zuckerberg. Me too. True, but on the other hand, you also have to acknowledge that they are also bringing tremendous advantages for all of the world.
Yeah, it might be common ground if you think in terms of use of the internet.
True.
The bad side, the good side. And we might come back to that. Let's see what time will allow us. I have a quick look at a question raised by Rebecca Mignot-Madavi again. It's a follow-up question, but it's my feeling that we have already been dealing with that in the meantime. If not, please inform us. And then there is another question tabled by Wilbert Jan van Heuvel. I'm still a bit of struggling with the microphone. He is raising a question for Ibo Buruma. And that's, I think you touched upon it a little bit already. He's talking about the possible relevance of international criminal law if it comes to, as an instrument, I would say, against cyber attacks or the consequences of cyber attacks. To what extent do they already fit in international criminal law, and what should happen in terms of lawmaking, maybe to make it fit, unless you think it should not fit?
Oh yes, I do think it should. We should try to make it fit. That's why I found it interesting what Wieteke and Marjolein said about a theoretically completely correct question they brought up. It's from a theoretical point of view, it's difficult how to deal with for the police with material that might be let's say located in some way in Finland or whatever. In practice, you see that the police is cooperating in very many cases quite smoothly with other countries, be it based on bilateral trade treaties or multilateral treaties or European treaties, whatever. And that's why I said, let's start looking at the real problems. And then from my perspective, I don't see very many real problems. I know that the police and the Public Prosecutor's Office in the Netherlands do have many questions, because from the perspective, from a strictly legal position, you might ask many questions, but in practice you see that the officers on the other side of the border are very willing to help. And that was my starting point when I said it's so important to look at these both lines of thinking. On the one hand, from the point of view of the system, and there's a lot of work to be done, and maybe new treaties can be, a new convention might be made, and in Europe new things might be done. True. But fortunately, in joint committees, joint work over the borders in Europe and in the whole wide world. Look here, even in what was it, Abu Dhabi, where this gentleman was being arrested. Even there, we cooperate in some way. So it's at this moment, it's not a good. It might be not a good system, and there are a lot of questions to be dealt with by experts as we are in this community. And now what the question was, can you give us an example? Well, not really, because I think almost always the problems that lie ahead can be dealt with. but maybe I'm overlooking something, and there will be a very clever attorney who comes to the Supreme Court and says, look here, there was a problem. And probably the Dutch Supreme Court will even say, that's not our problem, that you did something wrong against Germany because we didn't have it in a good capacity. And then it's for the Ministry of Foreign Affairs to deal with that question, whether the Germans are angry with us or not. Ordinarily, they're not angry at all in these cases, as I'm informed.
I look at Marjolein and listening to you, Ivo, I think there is a Dutch saying that says, if you want to solve it, you can solve it. And if you want to identify a problem, you will have one. But Marjolein, I was giving a signal that you'd like to react to this topic as well. International criminal law in relation to cyber attacks. Floor is yours.
Thank you very much. I think I think this is a great exchange because it shows that when you talk to people with different perspectives, you learn a lot. And I think it's very refreshing to hear from Ibo that he doesn't see many problems where when Wieteke and I talk about this almost on a daily basis, we feel that it's a huge problem. So I think that's absolutely great. I just think from our perspective, maybe what I started with in my presentation, there is a very big geopolitical context here. And this is why for us, it does constitute a big problem if the international rules are not clear. And that is that right at the moment, we feel that we are defending the international legal order in cyberspace because there are states that want to put forward that the rules are not clear, that there are no rules, and in essence, that they can do whatever they want without any consequences. So that is why for us, as government lawyers acting for the Netherlands in the Netherlands' interest, it's very important to get more clarity about which rules apply and what states may and may not do. I do agree with you. In practice, you see that it's very rare that states resort to international law to solve these problems. What they do exactly is indict individuals. For instance, the US usually does that. They just use their own criminal law to deal with these matters because it is very tricky to do it on an international level. But as I say, at the same time, when we talk about the group of governmental experts and the open-ended working group, for us, there's a very, very strong interest in those fora to get more clarity about these rules. And so, for instance, also about sovereignty, when does it apply, when does it not apply? And I must say, in our own discussions with the other ministries, such as defense and justice, they have a very strong interest also in getting these rules clearer because they want to know what they are allowed to do and what they're not allowed to do. So, but as I said, I really value this and I would love to have another discussion like this because I think it's really helpful for us to get a bit of perspective on these things. So thank you very much.
Thank you. But I agree with you on the other hand as well. I know that that's also happening, and that there are not only in the Ministry of Justice and Defense, but also in the practice of the police and the other services as well. Especially if you think of activities from foreign countries on our, let's say, our territory. How far can they go? That's something, of course, that never happens. That's never a question in my court, but it might be a question we want to deal with, because I would also be not very happy when, let's say, Kazakhstan is trying to influence our criminals or something like that. So maybe I was a little bit too positive, a little bit too optimistic, but I thought it would be, well, helpful to bring this other perspective in your view.
Can
There's always an option to agree, but not too quickly, I would say.
That's true.
Bad for the debate. Dan, and then Wieteke. Dan, you would like to react?
Yes. I on this topic, I would like to connect it to my second survey question. Remember that question involved a court in one country ordering data to be deleted in another country. I don't know what people said, whether that violates sovereignty or not, but commonly I get a response that no, it does not violate sovereignty. Then I find it very interesting if we change that scenario a little bit and say that the court is not ordering data to be deleted, they're ordering it to be a copy sent to them for law enforcement purposes. Then people always say, no, now we're violating sovereignty. So the conclusion seems to be that if you ask for a data copy, you are violating sovereignty. But if you require the destruction of the data, you're not violating sovereignty. And there seems to be a lacking logic to that in my view. So I think it highlights the one area is mainly seen as a private international law side, and one is a public international law. And I think there needs to be a dialogue between the two to get a greater consistency in this sort of topics.
Question
in a few minutes, but Wieteke would like to react to this topic as well.
Just very briefly, it's interesting to hear the different perspectives. I think once a case reaches a court, many of the steps have already been taken, and I think when you talk about gathering evidence that will eventually will reach court, whether or not initially this information was gathered without permission of certain authorities, in the end, as you say, Ivo, Germany would have had agreed to it. So consent is given, which is why there cannot be a violation of international law. And of course, in many of the countries that the Netherlands works with, there will be treaties for mutual legal assistance, there will be implied consent, which later on will always be confirmed, etc. But the interesting points which Marjolein also raised for us, because if it's a problem, as we rightly point out, between states, it eventually is a problem for the Ministry of Foreign Affairs to solve. That's where it becomes interesting, and where some of the questions are unanswered, and where there are different views, as Dan points out, on deleting data versus copying data, and it goes too far to address this in this short time span that we have, but there is a very interesting case eventually leading to the Cloud Act in the US that evolved around different countries. One was the US was requesting data from a server that was in Ireland, but the company was registered in the US, etc. So too far to discuss here, but this is one of those examples where eventually the US solved it by adopting a law that made everything okay again. But some discussions are not finished yet. But it's true that most of the evidence gathering between friendly countries will not be a problem. But it's just also true. That's how it goes.
Somebody used the words different perspectives, and I think this is what this is all about, isn't it? This is what we time and again search for also as an organization. Almost there. As a matter of fact, I have two things to say and one question remaining. The question remaining is one for Dan. I will introduce it. Then I would like to invite all four panelists to make some sort of a final statement. And the final statement could have two entrances. One is the title of the booklet is, of course, International Law for a Digitalized World. One part should be about stock taking. To what extent is international law, private and public, already ready for what the world we are in? And what would be your main wish if it comes to law making, the things that you change? And of course, you will not have time to repeat your reports. I would advise the listeners to buy the report if they did not yet do it, but you might draw or pay specific attention to one or two specific things as some sort of a sending away message. And then we will end up with the polls, again, the 6 pieces, bring them back to the 4 and see what you think in the meantime. And the question that was remaining is one tabled by Dr. Alina Ontanu. And allow me, Dr. Alina, to rephrase it a little bit. The question is, to what extent is private international law ready for the digital or the digitalized era? The question is specifically for Dan and also relates to Europe. And I don't know whether you know developments in Europe well enough to say something on that. But otherwise, you can run away with the question in whatever way you like.
That's exactly the sort of option I love. That's great. I can take it any way I want now. That's good. So it's an interesting question. It sort of links into what should be my closing statement. So in the interest of time, I can, in a sense, combine the two. I think if I were to compare public and private international law, I would say that private international law is better prepared for the digital world than public international law is. But much work lies ahead in both. I think primarily the first step in relation to private international law is really to increase the profile of the online side of things. We had to stop treating it as a side dish and treat it as something on equal footing with the offline legal issues that we deal with. Of course, I think it's a question of time as more and more scholars take an interest in the online side of things. It is going to even out over time by itself, but I think it would be a lost opportunity if the expertise of those who are not dedicated internet law specialists is not feeding into and informing the internet side now. So connecting this to some sort of concluding remarks, I think particularly in public international law, there is a lot of concepts of how we approach jurisdiction based on territoriality primarily. We're stuck with a Lotus case and the Harvard principles that are things from a completely different era. And in fact, in the Lotus case, I think it was the majority opinion that makes a point that you should only draw upon precedents that are similar to the context that you're dealing with. And that's not at all how the Lotus case has been applied. We're applying it to the internet context. And so there's a lot of concepts that we need to be willing to reconsider. Concepts should not be thrown out just because they are old, but we shouldn't be fearful of challenging existing concepts just because they are old either. We need to be prepared to reconsider the fundamentals. I've described this as, in a sense, what we're dealing with. There are genuine regulatory challenges, being the fact that some of the values that we try to combine, freedom of speech and the protection of reputation and so on, are difficult to reconcile and balance. These are genuine regulatory challenges. But this is a field full of artificial regulatory challenges in the sense that they are man-made challenges stemming from the concepts that we work with. And we need to devote more time to those challenges because only then will we be able to tackle the genuine regulatory challenges too. Enough for me. I know we are low on time, and I hand over to my colleagues.
Thank you very much. Now let me move to maybe Igor, if you're ready for your final statement.
Final statement,
stock
yeah.
taking ambitions.
Well, as regards to stock taking, I think that international law for a digitalized world is indeed in some way, well, I think it's ready. And I say that because for me, international law and all law is living law, is law in progress. There is never a moment that you can say, this is the law and now we can go on. No, it will change and change forever. But I think that a tremendous step has been made with the Tallinn Manual, it is already mentioned, and that from our perspective, we can, that's a starting point to go on thinking about international law and cyberspace. And I truly believe in that. And I have the idea that you can't say much more than that, that it is law in progress. And if there is then one issue that I would like to bring up now as a final statement, this one is that I hope that the Netherlands, the Dutch politicians and the Dutch academics keep on thinking in terms of let's say, our multi-stakeholder model, and that we are not drifting without knowing it into the discourse of the national sovereignty model. It's a model that is, of course, it's simple for the Russians and for the Chinese, and maybe nowadays even for the Trump administration it was, to think in terms of something that is only for your own country. And I think, especially for the Dutch as a trade nation, always with open borders and so on, it's extremely important to realize that other countries might have many other opinions we don't like, we really hate, but it's better to keep up these open borders and this interconnectivity with all these countries, and to find ways to go on with that from this. And I think then the multi-taskholder model is extremely important, because otherwise it's almost logical to go on thinking in terms of your own country or your own region like Europe. And that's why I bring these together so strongly. And for the rest, I think there's a lot of work to be done because it is a living law. And I wish you all, people from international law, a huge, a fine future in this field. I think in a couple of years, the issue will be back on your agenda.
Definitely. Thank you very much. Wieteke.
Yeah. Thanks. A few final words, and then I'll pass the floor on quickly to Marjolein, if that's okay. I don't know if you can see me, but I've been looking at my phone, and that was not to post anything on Instagram, but Marjolein and I were discussing who takes the floor when, just to inform you. So where are we now? It depends on also which group you have the discussion with. As mentioned, the UN level discussions are pretty basic, at least in the plenary, discussing the applicability of certain types of law. But the general consensus is that international law, existing international law applies, and then there are diverging views on whether you need new law in addition to that or not. My personal opinion is that at the moment, because we haven't even figured out how the law that we have should apply, it's too soon to say where and if there are gaps at all, and if there are gaps, where those are in the legal framework. So the discussion on how international law applies has not been finalized yet. The Talon Manual is a very useful document in that sense. It is a lex lata document. It doesn't say anything about law that may come into being in the future. It's a good reference point. It's not the law, it's a handbook, but it definitely helps in forming an opinion. And where will it go? I think some of the current norms, there are also norms of responsible state behavior that are not law, they're voluntary and non-binding, that assist the legal framework, often discussed in the international context. And those norms should guide states. I would not say now that those norms will never be law in the future. That might happen, but first we have to identify the gaps. And this is also when we participate in discussions with the drafters of the manual, the questions on where the law will go is one question that always is left to the audience at the end, with a famous, I think, Quo Vadis lecture of the teachers who drafted the manual. So we figure out how the law that we have applies, and then we take this discussion further. That is where I would leave it. And I would like to give the floor to Marjolein, if that's okay.
Sure, Marjolein.
Thank you very much. Yes, I fully agree with what Wieteke says. And I must say, I really liked this discussion. It's very invigorating to have discussions like these. Because as Wieteke says, when we speak at the UN level, it's in a sense more basic and more technical. And I think what I like here is that we all agree that we need a lot of creative thinking and a lot of progressive thinking to deal with the digital age, applying legal concepts that have been developed years ago. I just two more remarks. One, when we talk about how international law applies to cyberspace, from our perspective, I think there are two, aside from the things we already discussed, because as I said, I do have strong feelings about human rights. I totally admit that, that's absolutely true. Aside from that, I think there is a problem, or let me say a challenge right now for states like the Netherlands, who really want to adhere fully to international law. There seems to be a disbalance, so to speak, between sorry, I'm not very articulate. What I want to say is that the response options for states like the Netherlands are limited when we are confronted with state behavior, even if that state behavior violates international law, because international law is very restrictive in giving state response options. International law, I think, is more geared towards letting states solve things through negotiations and through going to court. And what we see in cyberspace is things happen so quickly and can cause so much damage that I do think that when it comes to response options for states, that there we see a big tension with what we would like to do and what we are allowed to do. So I think the debate will focus on that, or should focus on that. And finally, I couldn't escape it, coming back to the human rights, I think one big issue that we really need to solve, or at least make progress on, is the extraterritorial application of human rights, because states nowadays can act everywhere on the globe with, and I agree with in that sense with Ivo. I don't think right now, if state violates the privacy of 22 million citizens, I agree. I don't think where the law stands right now that is in violation, but I do think it should be. And so I think we need to come up with a more workable approach to the extraterritorial application of human rights. And I know that there are proposals already being put forward. We go into it a little bit in the report, but those are, I think, the main issues where I think we really need progress. And then final remark, what I as a lawyer have come across is that many times we are talking about very technical things, and sometimes I feel very ill-equipped to make a good judgment as to how the law applies, because I simply don't understand the technology. And I think there also that we international, and all lawyers maybe, we really need solid technical expertise and knowledge to be able to apply the law in this new domain. So I think there also, that is a challenge. And I don't know, maybe universities can pay more attention to that, or and certainly we as a government maybe have a role, but that is one clear challenge also that I see. Yeah, that's the remarks I would like to make. And I just want to thank you again for inviting us, because this was, as I said, it's very refreshing for us government lawyers to have discussions like these. So thank you very much.
For us organizers, it's also very much refreshing to bring these perspectives together. I'm sorry. For us, it's also very refreshing to bring these perspectives together. We are now almost at the end, 4:15. For Dan, I think, the middle of the night in the meantime. What I would like to say is only a few words. First, the panelists have done today a very good job, but the real work, of course, they have been doing in the first half of this year, writing these reports, discussing them, challenged by us to do many things, and they are very much, these efforts are very much appreciated. And for those who did not see the book yet, it's still available. You can buy it, and we never have very high prices, and I think it's also very important stuff for master students, law firm people, and what have you. For each of you, there is a token of appreciation. We will do that partly physically and partly handed over via snail mail, Marjolein and Dan. At some moment it will reach you. And let me end by saying something on which I started. I don't know whether the United States of America in the meantime has a president-elect or not, or whether they make progress on this. But should it be Biden, which I can say, I hope, it will make a change on Paris. It will make a change on the WTO. It will make a change on the World Health Organization. And even if we should not dream ourselves rich, I would say, even then it will have an impact on our work. And what Wieteke said, I think it was you, about the Quo Vadis lecture. Quo Vadis, yes, this organization is time and again involved in discussions on Quo Vadis. What are we going to do? And then it's very helpful that a president of a powerful nation, which the United States still is and will be, it's that he at least is partly on the same side of the medal. Thank you very much for all the efforts, the written ones, the oral ones. Thanks to the participants, the audience, the You use the chat function, the Q&A function, and I hope you are by and large satisfied by our performance. Thank you very much.